this talk relates to a case which I was involved in, which was heard in the Court of Appeal in March of this year. You'll see the citation there on the handout. Unfortunately, it resolved by way of settlement, so we were deprived of a judgment. We were actually being live streamed on YouTube for the duration of the appeal, so you can still Google that and it will come up and you'll see. That appeal concerned an issue which related to the interpretation of the third party's Rights Against Insurers Act 2010, which has a very catchy name. I shall refer to that as the 2010 Act. There's another act which came before that, Third Parties Rights Against Insurers Act 1930, which I will catchily call the 1930 Act. And there's a few cases as well which I will summarise. But the issue that arose in the appeal can be summarised by the flowchart on the screen now. It's a case where you've got a cause of action which accrued against the defendant, a winding up order made in respect of the defendant, limitation on the face of it expires after the winding up order is made, but before the 2010 Act claim is issued against the insurer. So the question that this appeal dealt with, and which I'm going to try and address today, is that claim in time, notwithstanding that limitation is on the face of it fully expired as at the date that the claim form is issued. It's quite an old case, but the principle in this case is still sound today. It concerns the interpretation of insolvency legislation, which hasn't changed that much, the relevant provision. But the principle from rolling stock is that if a claim is made against a company in liquidation, that claim is in time regardless of when it's made, provided that it's in time at the date when the winding up order is made. So the limitation clock is frozen for the purposes of that claim upon the making of the winding up order. We park that theme for now, and then we go and explore insurance law for the rest of this talk. But that principle must be borne in mind because it is very relevant later on. Harrington Motor Co. 1928 was a claim where the claimant was involved in a car accident. He was injured by Harrington Motor Co. Limited, and he brought a claim against the company for his injuries. He had a cause of action against the defendant in tort. The defendant became insolvent, but the defendant had a contract of insurance which insured him against the liability which he'd incurred towards the claimant. So you've got a tortious relationship between claimant and defendant and a contractual relationship between defendant and insurer. There's also various other claims against the insolvent defendant as part of the insolvency. So all the creditors were owed money and they had various claims as well. The point that was made in Harrington was that the claimant has no direct right against the insurer in those circumstances. The way the claim would work is the claimant would claim against the insolvent defendant. The defendant would then claim against the insurer. The insurance monies would be paid by the insurer to the defendant and then paid out to the claimant. But because everyone else is queuing up for money as part of the insolvency, there's a problem there. And the way that problem was resolved in Harrington was that the insurance proceeds are lumped in with whatever assets the company has and are distributed amongst the creditors of the insolvent defendant. So the claimant, even though he had a claim which was insured, didn't receive all the money that he was supposedly entitled to because of the fact it was lumped in. And this had a very bizarre consequence. Why bizarre, do you say? Well, it's bizarre because the defendant in that situation is motivated to commit torts or commit breaches of contract. Yes, he's insolvent, but the director could go driving about in a company vehicle, mowing down pedestrians, crashing into Rolls Royces, demolishing buildings. Of course, he'd be insured because it's used for motor vehicles. So by generating additional liabilities for the company which are insured, it then increases the amount of money that comes from an insurer into the company pot, increases the amount of money available for creditors, and it's all split pari passu. So the actual victims of the torts and the contracts, etc., wouldn't actually receive an awful lot of benefit, but the other creditors would. So it created this bizarre situation where it motivated you to breach your obligations. Parliament saw fit to intervene with the 1930 Act. You'll see the money has moved back across, but there's a couple of innovations with the 1930 Act. This solved this problem by creating or rewriting the relationship between claimant, defendant, and insurer. So gone are those relationships. And here we have a contract of insurance imposed by statute between claimant and insurer. So what happens is when a company or an individual becomes insolvent or enters bankruptcy, it triggers an automatic transfer of contractual rights under the Act. So the claimant inherits the contractual rights that the defendant had against the insurer. So the claimant could enforce his claim directly against the insurance policy. So he bypasses the insolvency. He gets all of his damages minus the policy excess, subject to policy limits, which are points we'll pick up later. But it solved this problem. Post Office in 1967 was a case which looked at this side of things. So the Act had dealt with the insolvency side of things, but there was a practical element, which is that most liability policies, well, all liability policies by definition, require you to establish the liability of the defendant, the person who did the tort, the person who crashed his car into you. You have to show that they were liable for the collision, for the tort, etc., for the insured liability. Post Office held that you have to do that as a preliminary to doing a claim against the insurer. So it created a caveat to the statutory transfer. You can only enforce those rights once you've established liability against the defendant. So you have to do one claim to establish liability and a second claim to enforce against the policy. Slightly cumbersome because it creates a duplication, potentially problematic because if the defendant has been dissolved, you have to go to the High Court in order to restore them, in order to get your liability judgment, and then you go against the insurer. So it creates a lot of hassle and a lot of mess. But there's a limitation element to this as well. Because you've got two claims, your initial liability claim against the defendant is governed in terms of limitation as regards the defendant. So applying rolling stock, that would apply to that bit. And in respect of your second claim, because that isn't the claim in negligence, that's a claim on the policy, and that cause of action against the insurer doesn't accrue until liability is established, it means you've got a second limitation period running. So because you can't sue the insurer, because your cause of action against the insurer doesn't complete, you can't sue them until you've established your liability, you've got a secondary limitation period. This is what came up in Larnell. I've perhaps given the game away a little by the way I've described that, but what we have here is a claim by the Financial Services Compensation Scheme against Larnell, who was giving out allegedly negligent investment advice. Winding up resolution was passed. Limitation on the face of it expires before the claim is issued against Larnell. Of course, the Financial Services Compensation Scheme isn't being advised by Larnell. They were assigned the cause of action by the investors. Limitation is frozen upon the winding up resolution being passed, upon the company entering the liquidation process. And it's important to remember that Larnell is a claim, it's part of the first claim, it's the liability claim. So it's FSCS claiming in tort against Larnell to establish liability as a precursor to the claim on the insurance policy. Now, the rolling stock argument wasn't received very well by Larnell's insurers because Financial Services Compensation Scheme obviously didn't want to get a remedy from Larnell. They had no money, they'd gone bust. Their target was the insurance proceeds. So the argument in Larnell that the insurers ran on the part of Larnell, because of course when the insurers are involved, they ultimately say how you've got to defend your claim. They said that because the target was different, because the target was money outside the liquidation, outside the insolvency, that the rolling stock principle shouldn't apply, because the rationale for the rolling stock principle is grounded in insolvency law. The basis for that decision was based on a claim against assets within the insolvency. And they said, that rationale doesn't apply here because the target is something outside the insolvency, something outside the liquidation. Court of Appeal disagreed with that analysis. And the point that they made in there was that the limitation period cannot be defined by your intention and your target when it comes to pursuing a claim. the limitation period should be the same regardless of whether you want to pursue assets within the insolvency or outside the insolvency through the insurer, because it's the one cause of action in negligence. Remember, we're dealing with stage 1 here, the stage 1 claim. So you should be able to go off and get your judgment against Larnell. One of the key reasons for that, when you think it through, is that insurance rarely covers 100% of your liability. 9 times out of 10, there's an insurance excess, £500, £1,000 or so, and that first chunk of money is never paid by the insurer because that has to be paid by the insured. So theoretically, if there were some assets in the insolvency, you might get 2 or 3 pence for it, but you might get a 2 or 3 pence contribution towards the element of your damages claim, which would have been covered by the excess. So although it's intended to be a claim against the insurer, ultimately, the instant claim actually would bind both of them and would have consequences for both of them, in that in theory you can also get assets in the insolvency. It may well, of course, be that the insolvent insured suddenly comes into money if there's a cause of action that they have that was waiting to be processed, a pending claim, or if they owed money that was suddenly paid in, they might come into funds, which might change the whole thing around. But as a point of principle, it was held in Larnell, the rolling stock principle does apply to the first stage of that claim, the liability claim. Before we get onto the 2010 Act, it's important to look at the chronology again. So you've got rolling stock in the 1800s, limitation is frozen. Harrington Motor Co., which made the point about, it created a problem that the 1930 Act solved. 1930 Act created your right to go against the insurer. Post Office tempered that and said it's 2 stages. 2001, the Law Commission drafted the 2010 Act. They said in that report in 2001, it's cumbersome going under the 1930 Act, wastes money, it wastes time. Wouldn't it be convenient if we could go direct against the insurer for everything, one claim to solve them all? Before the 2010 Act came into force, or before it was given royal assent in 2010, that was when Larnell came. So Larnell was decided before the Act was passed. Did the Law Commission review its report after Larnell? Of course it didn't. Why would you bother to do that? So the 2010 Act was passed and enacted without considering the effect of Larnell, without considering the confirmation that rolling stock applies to 1930 Act claims. Herein lies the uncertainty and the problem that was at the very heart of the appeal. So the way the 2010 Act worked was very similar to the 1930 Act, in that as soon as the company enters into insolvency, the contractual rights against the insurer are transferred to the claimants. The claimant can go against the insurer. It's different in that the cause of action can be done directly against the insurer. So you can do a 2010 Act claim without having to involve the defendant insured. It's a much quicker way. You don't have to restore them to the register if they're dissolved. You can just go straight against the insurer. That's done by the mechanism of declarations. So you get a declaration against the insurer to establish liability, a declaration as to say that the policy covers the insured liability, and or the extent to which it covers it if there's limitations to it or policy limits. And you can do that all in one action. Section 2.4 says the insurer can rely on the insured's defences, which would, of course, include a limitation defence. And Section 2.9 significantly says that the claimant may join the insured to the claim if they want to. So whilst you don't have to join the insured, the insolvent insured, you can if you want to, which is important from a conceptual point of view, because if you do, it puts it on all fours with Larnell, because you've got a judgment there which binds both of the defendants. Alongside all of that, you've still got the old 2-claim method. Why you would want to do the old 2-claim method when this exists, I've no idea. No one's ever really explained it in the Law Commission documents. I certainly can't think of why you'd want to do it. But Section 2, the bit about the declarations, only applies where you haven't already established liability. So if you wanted to, you could do claim number 1 against the insured and then claim number 2 under the 2010 Act, relying on the contractual rights to get your judgment against the insurer. There is a bit in Section 12.4 which deals with the position where you do the old 2-claim method, and it says nothing in the Act changes the fact that the cause of action against the insurer only accrues once liability has been established. So it expressly preserves that rule, which of course came from Post Office, but it says nothing at all about how limitation works in Section 2. So it's a bit of a blank canvas. I'm going to look now at the two stages of the 2010 Act claim. So bottom right, you'll see in bold, we're going to start with the declaration to establish liability against the insured. And what happens when you look at this side of things is the insurer stepped into the shoes of the insured, and there's them moving across. So they put on the insured's hat and they defend the claim as if they were the insured. They rely on their defences. Might be contributory negligence, might be limitation. But the point is that the insurer can only rely on a limitation defence if the insured can rely on it themselves. And because they are the defendant insured for the purposes of this stage, rolling stock prevents the insured from relying upon any limitation defence if limitation only expired after the onset of insolvency. And Larnell held that the target of the claim is irrelevant. So the argument which the insurers ran in our appeal was that because the claim under the 2010 Act is against the insurer, and you don't have to go against the insured as well, it's entirely outside the insolvency, and there is no joining of people. There is no judgment which binds both. There is no prospect of anything being recovered in the insolvency if you only go against the insurer. The reason why that argument's wrong is because of the rationale in Larnell. We were in the Court of Appeal. Previous judgments of the Court of Appeal bind the Court of Appeal. Larnell, and that's the same side as earlier, makes the point that whether a claim is limitation barred cannot depend on the intention of the person bringing the claim or the target of the action. So Larnell rationale is equally applicable to a 2010 Act claim as it is a 1930 Act claim. Stage B, the declaration as to the insurer's liability under the policy. The insurer defends the claim in terms of the terminology in the policy itself, the interpretation of the policy document. The insurer relies on in exclusion clauses within that policy limits, etc. No limitation defence for the insurer because the issue of liability is what contained the potential limitation defence, but because that's already been resolved, that's gone, and that isn't part of stage 2, because stages A and B are two separate stages, despite them being part of the same claim. You can bring a claim for the 22A declaration without doing a claim for the section 22B declaration and vice versa, so they're conceptually individual items.